thank you all for your attention. I mean, it's one of the last panels now before the reception. I hope this will be a lively discussion for all. We did prepare a conversation about e-privacy and the omnibus and Article 88 in the exceptions. So this may be, because of the expert knowledge, a little bit more of a technical conversation. But I do want to invite you all at the end. We're going to save about 15 minutes for engagement with the audience. So bear with us. I will first start with introducing our panelists. And for each, I'm going to add a fun fact as well, just to make this a little bit light. And let me start with Cristiana. Cristiana Santos is assistant professor in data protection law at the Utrecht University, with a joint doctoral degree in law and computer science. And there are not many people in this hybrid space, so that's quite laudable. But it's also great to note that she was recently awarded a Dutch VIDI project to research power. So this grant is a grant that's very important under Dutch research umbrella. And she's going to focus on the research of power, manipulation, and controllerships in data protection. So the fun fact here is that Cristiana loves medieval castles and fortresses, and she visited more than 50, including the 1,000-year-old Bouillon fortress in Belgium. But Scotland is next on your list, if I understood correctly. So next, we go to Itxaso. Itxaso Domínguez de Olazábal is a policy advisor at EDRi, working on data protection, cookies, e-privacy, but also on the political economy of commercial surveillance. And her work explores the intersection of technology, surveillance, and the protection of individuals and collective rights, particularly for vulnerable communities. And her fun fact is that here in the streets of Brussels, she walks 2 to 3 times longer than planned because she can't resist stopping to say hello to every cat and dog that she meets. Well, Rosa, your fun fact is still coming up, but let me introduce you as a seasoned data protection, data privacy, and cybersecurity lawyer, currently at McDermott Will Emery, specializing in GDPR, e-privacy, NIS2, and other EU digital laws. She has worked at the European Commission, EDPS, and currently chairs the Brussels chapter of the International Institute of Communications. So you told me, and that's what I'm going to share now, that your daughter is left for university and left behind Rupert, the dog, who's now your constant companion. So, Itxaso, it looks like you're going to have more furry friends to stop for. In any case, we've spent over 2 decades trying to get cookie regulation right here in Europe, from the original e-privacy directive in 2002 through the failed e-privacy regulation negotiations to today's omnibus, a proposal package of simplification. So let's start with the bigger picture here. Itxaso, what exactly is the proposal trying to fix? What problem is the digital omnibus proposal trying to solve in the e-privacy space? And how does this differ from the approach taken in the privacy regulation proposal and others adopted within the digital rights community?
Yep. Thanks so much. It's an honor to be here. And it's an honor to be speaking after Anna Bradford, I think, after everything she said. I think we all should take a moment to digest, because I think those were very important points, and also how she's encouraging us to fight for rights. And I think this conversation, the whole conversation, is about rights, the fundamental right to data protection, but also the fundamental right to privacy, which are 2 separate fundamental rights. One of the things that I wanted to mention is that I represent EDRi, which is a network, European digital rights, of more than 50 organizations, experts, and individuals. And everything that I know about e-privacy, I've learned from them and from some of the amazing experts in the room. I won't name names, but yeah. And I think it's really important to understand that all of this expertise comes from years and years of debates and fights about e-privacy, and all of this seems to be gone, right? E-privacy, the e-privacy directive was devised, was adopted for a very specific reason, which was to protect the fundamental right to privacy, secrecy of communications. Article 5.3, which is the main article that seems to be at stake or targeted for the digital omnibus, was about access to device and terminal equipment. And afterwards, we can discuss how this is completely different from just processing personal data, and how, e-privacy is a Alexa specialist and a complementary law to GDPR. But e-privacy as a whole is in danger, and we've heard that very clear this week from the European Commission. You know, that some people in the Commission have been hating e-privacy, the idea of e-privacy as a whole, for years, and now they find a way to dismantle this. And I think it's worth remembering why is e-privacy so important? Why is privacy such an important and such a central fundamental right for the history of Europe? I don't think I have to give historical examples of why privacy and not just data protection is important. But nowadays, you know, we're not just speaking about phones, we're not just speaking about computers, we're speaking about many, many devices that under this idea of the Internet of Things are connected to the Internet and are actually, you know, participating in huge amounts of data flows with the most intimate data that we can share. Personal data and data that could not be considered in principle as personal data, but that's still very important in order to be granted protection. And that was, you know, the spirit of the e-privacy regulation, right? We knew that the e-privacy directive was not modernized enough. You know, there were some patches, there were some interventions, we had guidelines, but there was this compromise, this consensus, whereby it needed to be modernized and it needed to be harmonized. Because one of the problems that we hear needs to be solved is this lack of harmonization, because it was a directive and enforcement wasn't working, right? Both from a harmonization perspective, but also because DPAs or the supervisory authorities in charge of electronic communications were not able to actually enforce the law as it was meant to be enforced. And again, the e-privacy regulation tried to do that, and you know, the process was super advanced. You know, we had the Parliament text, we had the Council text, and at one point it was told no compromise was possible, and it was withdrawn. And it was like, okay, we tried. Nobody understood why such an important text was withdrawn. Such an important text that tackles both commercial surveillance but also state surveillance, and the intertwining between state surveillance and commercial surveillance that nobody seems to mention nowadays, but we see more and more news. I don't know whether you saw the Le Monde investigation about data brokers and companies offering law surveillance authorities, you know, incredible amounts of data, an incredible amount of different kinds of data. And so we didn't know what was going to happen with e-privacy. We were told it was going to be Frankenstein, you know, some of it to data retention, the cookies part maybe to the DFA, and the digital omnibus came as a magic solution. And we were told it was going to address e-privacy. And it was going to address e-privacy from the perspective of e-privacy being an obstacle to companies getting more and more data. And that was clear from the data union strategy. That was already the first concern. You know, again, why should we be so worried about companies accessing data, whereas we should be worried about companies respecting the law, a law that wasn't enforced enough, because we know that there's business models that are completely illegal, that are abusing our data, that are constantly tracking every step, every breath we make, like the police song. And that was, the digital omnibus was also proposing something that was quite radical, if you really believe in the difference between privacy and data protection, which was shifting most of it under the GDPR, as long as it is personal data or leads to personal data. What does that mean? And again, this idea of completely undermining this principle of confidentiality of communications and not understanding why access to device, access to terminal equipment and storage is so different from collecting and processing data is already a huge problem, is already a huge issue. And if you combine that with this deregulation approach, which is, oh, let's undermine fundamental rights, let's undermine safeguards, let's try for companies and for controllers to get as much access as they can without friction, which friction sometimes can be positive. I'm really sorry. I know that it entails costs. I know that it entails professionals, but we need to comply with the law, and all of it, you know, this is for all companies, not just for companies applying digital laws.
Well, this is like the base layer for the discussion.
Sorry, it took so long.
No, it's fine, because I'm going to ask you a follow-up question. So the proposal positions itself as a simplification, but that framing seems contested. And let's unpack what's actually changing in the legal architecture, starting with the consent first principle that has been central to e-privacy, obviously because there are two fundamental rights, different fundamental rights to protect. Itxaso, how does this proposal affect that? So how does the proposal affect the consent first logic traditionally associated with access to terminal equipment under Article 5.3 of the e-privacy directive?
So, yeah, I think the thing is that, you know, I'm going to come back to the e-privacy regulation, because under the same umbrella of access to device, there was this realization, and that came from industry, but that also came from a somehow pragmatic approach, that the consent rule of Article 5.3, the so-called cookie rule, which shouldn't be called cookie rule because it's all about all kinds of tracking, maybe was too strict for some users that wouldn't grant consent, right? And there was, again, years of negotiation about a very specific wording that would allow for certain exceptions, like now we have like this idea of strictly necessity, but that will be about audience measurement, that will be about security, but security defined and that will be about applying certain principles, right? Nowadays, we also see this broadening of the exception under GDPR, but with wording that actually doesn't meet and could be interpreted and will be interpreted if it's not changed by the actors that actually don't want to comply with the law in order to collect and process data and harm people with this data. It's true that we have the other part of the equation, which is the privacy signals, and most of us were really happy. That's something that we have been advocating for years. Yay, privacy signals! We come here after California, whereas we should be the first to do that. But even when you look at privacy signals, it's going to be, and maybe we can discuss that afterwards. But the way it is worded even now, it's really concerning that you have all of these exceptions, all of this broadening of exceptions in order for companies not to have to ask for consent. But then you have to wait for 2 years or even potentially 4 years so that all of these privacy signals are going to work instead of making them legally binding from the very beginning. And even worse, and I'll stop after that, introducing exceptions, which is like a media exemption. I'm fully supportive of media needing money, but they don't need to get exemptions in order to be collecting our data. And an SME exception, which if you look at how SMEs are being redefined through other digital omnibuses, we have already discussed all of the insufficiencies of the process, so I won't even go into that. It's even more worrisome. Like, you open the door for all of these exemptions. Who is going to actually, benefit from that, and who is going to actually not benefit from that? Whereas enforcement of the e-privacy directive, nobody is addressing that with these new changes.
Rosa, I'm going to bring you in. We are talking about exemptions and exceptions. But let me ask you the question. According to the Commission staff working paper, which has all the interesting bits about what the simplification means, the current Article 5.3 has caused substantial burden for businesses. And do the proposed amendments improve the business position? And if so, does the proposal strike the right balance? I'm very keen to hear your views.
Okay. Okay, first, Rob, thank you for the question. Thank you, the EDPS, for the invitation to be here and to speak about this topic, which is quite dear to me. So, and I'm very happy to share this panel with the core panelists. So then I go to your question, but I am going to go to your question a bit rambling. I would like first to just answer the question maybe from a point of view of business and individuals. So does this proposal improve the situation? Is a good proposal? I might not see it from one angle, so looking at them from both, I find the proposal quite well balanced, actually. I think that when you look at it, for high-risk situations, we have still consent. So whenever access or storage in the device is based on high risk or any risk, the consent prevails. So it's a bit like a status quo. And then we have the exceptions. The exception that we have, there is 3 more that we don't have today. I think Itxaso comment, so is necessary for the service. Today we have is necessary for an information society service. So when you request service, if it's necessary to access the device, it's okay to access the device without consent. What is the change? The change is that rather than information society service, now the proposal says service. That kind of makes sense. Makes sense because sometimes an information society service is a defined term, defined in a directive. Not all the services qualify as such. E-government portals, they are not by remuneration, they are not. So it kind of makes sense in some cases to say service and not information society service. Now, you look at the security exception. I think one can tweak it, maybe is open, but when you look at this exception, in my daily life, I advise companies, I look at the guidance of the different data protection authorities. These exceptions, some of the data protection authorities are already using it. Take the CNIL, take the Germans, they have this exception. So to some extent, this, what the Commission has done, reflects a bit of a status quo. Not all the authorities have it, so by incorporating, it harmonizes throughout the EU. I think that this is good for business, and I don't see a downside of risk impact if it's properly drafted. And then the last is on analytics. We will discuss more, but for those, maybe you were there, I think I was there, in 2012, we drafted an opinion, and the opinion on first-party analytics already recommended and told the Commission, you Commission, if you pass a new law, please put an analytics because this doesn't impact, subject to many requirements. So to me, the proposal is, how do you call it, is an evolution, not a revolution. So all in all, I think that these things help business and helped also the society as such. Now, I do see some challenges. And besides, for companies that is, before going to the challenge, I also see another advantage, which is the one-stop shop. If it comes under the GDPR, from a company perspective, the one-stop shop helps. If you look at the other side, it also exposes to fines. Now today, if you advise a company and tells you what will be the fines for not complying, well, the fines, they are not exactly the same. In some member states, the fine might be really minimal. So today, because the e-privacy today is implemented differently in member states. Some member states might have GDPR fines, but others might have very small fines. Now, when it comes to the GDPR, the fines will be harmonized high up. So I think that the thing is in the middle.
But the one-stop shop mechanism is not really working.
Okay, this is a kind of one, but okay, if it's, yeah. Now, the challenges for this that I see, one challenge that I see is that the Commission, when you read, okay, this will help to diminish banners. I think that helping to diminish banners, there is still a lot of cookies that will require consent, rightly so. For example, the marketing cookies. So you only see the possibility to remove the banners with the signals. Now, and this is a call for the lawyers, when I read 88B and 88A, I don't see in these two articles a connection, meaning that if the browser manufacturer gives individuals the possibility to choose, and I don't choose, there is nothing that says that the browser manufacturer will have to force me to choose. So if I don't choose, as many people in the room don't choose, and I don't send a signal to the website, what is the website going to do? Do they drop a cookie or not? If I were the website, I would not drop a cookie because I don't have consent. What would I do? I will say, here is a banner. I bring the banner. So this is, I think, is not well yet connected. Is a small thing that will need to be connected because otherwise the problem that this intended to solve will not be solved. So, but this is a connection between 88A and B. And we have a repercussion on the browser and and other small things. So I think I leave it here. This is my sort of overall.
I'm going to bridge to the deep dive, and Itxaso, you'll be the first one to respond. But let me first bridge it with a couple of sentences. So far we've established that the proposal shifts the legal framework and attempts to balance business needs with user control. But much of the debate hinges on the exceptions, what's carved out from consent, well, basically the exemptions, what's carved out from consent requirements. And let's dig into those. What's at stake? So what's the role and impact of the exemptions in the proposal? And you can obviously respond to Rosa's position.
I think I was too fast because I answered that in my previous response. Yeah, I think every time, and I think there's also a huge problem in already creating carve-outs from the get-go because you're sending a signal, speaking of signals, that further carve-outs can be allowed down the road. And also all of these signals are there for the wrong reasons. When you look at the recital that has to do with the media exemption, you know, again, love media. I think media has a huge problem. I think that huge problem has lots to do with big tech and the way big tech is not allowing media to flourish and has been stealing media's business model for years. And now you see a fundamental rights law that is going to use the rationale that media is very important for democracy and society, which I fully agree with, in order to actually undermine a fundamental right. Are we playing that game? I think, again, is that legitimate? Doesn't that go against primary law? I think it's worth asking that question. But I wanted to also build on what you just said, because you asked about legal certainty. And something that we need to really think carefully about, and that was brought up in the previous table, is it's not just about the changes to article or the new Article 88. It's also about the interplay between other proposed changes and the changes to the Privacy Directive and GDPR, especially when it comes to the definition of personal data. And that doesn't really provide legal certainty when it comes to whether Article 5.3 or Article 88 GDPR applies. And I've been trying to do a brain map with 1,000 options, because I really see the option of companies advocating for the data that has been obtained and is going to be processed being personal data, because then you can use legitimate interest and other legal basis, but afterwards it magically becomes non-personal data because it has been pseudonymized, or you have been using one of these magic pets that keep being mentioned without actually mentioning which pet and how it is being used and how it is being combined, or the other way around, right? You know, it's because the data from the get-go is pseudonymous. It's not personal data. You have obtained that with consent, but afterwards you're going to say that because it's aggregated, because you're going to use it for audience measurement, then it follows under the exemption, and that doesn't really provide legal certainty for me as a person in the European Union that is subject to all of these abusive practices. And I think maybe we can speak about deceptive design afterwards, because nobody speaks about dark patterns at deceptive design and how this consent is being obtained and why consent or cookies fatigue have become a problem. It doesn't provide certainty to companies, and I've heard that from companies themselves. It doesn't make it clear which authorities are going to come in, and actually authorities are having a huge problem, and they're asking the right question, and the Commission hasn't been able to actually provide with an answer. How is this going to go? And yeah, having the one-stop shop mechanism, it's not going to solve it all. So I don't see any shred of legal certainty. And again, we're still, and I'm sorry, I'm going to have to emphasize and to underline and to be really annoying with that, but we're doing all of that by shifting something that has to do with access to device and terminal equipment into a law that wasn't meant to protect that. And that doesn't, and we're not looking at what does it happen when you access the device or the terminal equipment. We're not looking into that, and that's a huge point of abuse.
Yeah, obviously, the SRB ruling and the impact on the definition of personal data is the elephant in the room. And that's because of the modern advertising systems are basically a network of actors. And some have the luxury of having a direct access to the user's browser. And then it's more, the legal question is not too complicated, but if you share that information out to other actors, Whether it's still personal data for them, obviously, is very easy to answer. It will not be, a cookie in itself will most likely not be personal data. And that makes it much more, so that's a very separate discussion to have, whether that lowers the protection of fundamental rights in the end. But let me bring in Cristiana here, because we've not heard from you before. And the question to you is, does the proposal change anything for analytics, and possibly with practical examples of first-party tools that may still conflict with confidentiality principles?
Thank you, Rob. I think Itxaso already brought up the issue of analytics exemption in the proposal. So I'm reading Article 88A, paragraph 3C, which exempts from consent analytics that build aggregated information and that is website operated and for website use. However, there are indeed certain technologies that fulfill with these requirements, but they have not a low impact, but quite a big impact on data collection. So current server-side tracking technologies allow and enable website owners to allocate, to include tracking directly on the server, not on the browser, and track users seamlessly. And so the data collected by such tracking, for example, for certain analytics, are shown to the website owner, to any auditor, but to regulators as first-party data, as normal communications between the browser and the server. And one concrete example is Hotjar, a very known service that website owners deploy to understand how users navigate their websites. What is interesting is that in our legal and empirical work, Hotjar collects a lot of data. And I will read it. It collects the URL, the data visit, the time that users spent on websites. So the scrolling actions, key presses, mouse positions, the browser, the operating system, the language, screen resolution, IP addresses, etc. So highly identifiable data. And this amount of data and the granularity that this data includes, is it necessary for the website to work? No, is it? So the sheer volume of such data provided by such a tool, which could be seen as a first-party tool to websites and to regulators, are being exempted of consent under the current proposal. So I find this problematic, and this is just one example that I wanted to share with you.
All right. Well, we've talked about what requires consent and what doesn't. So now let's turn to how consent actually works in practice. Let's zoom in on the mechanisms, the signals, and the user experience. And I want to bring in Rosa with the following question. What do you see as the main challenges in the standardization of giving consent through machine-readable consent signals? What's your perspective?
Okay. So, anticipating this standardization, I have the feeling that we will encounter a problem. I'll try to see if I can explain, because I tried before at home and I don't know it will come right. So, on the one hand, you have the GDPR. The GDPR, in order to get consent, requires providing information as to what you are consenting. So telling about the identity of the controller, which data you collect, and for what purposes. Today, how is this complied? With the banner, with the CMP, with the management tool, which will enable, we will list each cookie for this purpose, for so long, and that's what we do. So that's today. In the future, I think that when you imagine all this tool into a browser, I think that for this tool to be able to be usable for an individual, to have all this granularity might kill it. Because if an individual somehow has to go and decide cookie by cookie if yes or not, into the browser, how this will work out, I find it difficult to imagine. So in my view is to comply with a GDPR, strictly speaking, consent, it will be difficult. Now, I think it will be easier if the GDPR consent could be constructed by purposes, so that you could choose in your browser purposes for which you want access, you want cookies, let's call it, or other devices. So if we could say purposes, that is feasible, because you will say purpose marketing, yes, no, purpose analytics, whatever. But if it goes into a very strict GDPR way of seeing the world, I think it will be challenging. I don't know, again, that this is my kind of intuition. And so maybe I will be very happy to hear other people's views.
Yeah, bringing in Cristiana. So one-click rejection and dark patterns, consent fatigue, including interface issues and backend compliance gaps. What are your views there?
Can I just have a quick note on this GPC?
Yeah, of course.
Sorry, and I come back to the dark patterns, delicious topic. So there are no current signals that are silver bullet, but there are current signals that could somehow at least alleviate and facilitate the exercise of certain GDPR rights. For example, for objection of legitimate interest, or for rejection and for withdrawal. At least, and for rejection, right, and for withdrawal, so for revocation as well. It's not a one-size-fits-all solution, but we could also learn on the virtualities and limitations of signals that are already being deployed widely and that are actually enforced. And so why not regulators understanding what are the virtualities of the current signals, benefits, and how could we learn from them and uptake them here? And I know that would indeed be the solution, or a potential partial solution for consent fatigue.
And this is an opportunity for EU companies to actually, create a business, create a service that is actually useful and rights compliant.
But let's come to, so in principle, GPC or alike, there are some demo solutions, demo proposals in the EU that are being somehow constructive and aligned to GDPR, but what we can learn is already signals under use. I know that you will come to this, but let's go to these dark patterns one-click rejection proposal. So I find it a good proposal, but it's somehow a cosmetic issue. Why? It indeed avoids dark patterns, so avoids that that users spend more time, more clicks to reject consent, which actually should also apply to revoke consent as well. But what I find is this is a mere incentive for CMPs and the like to exploit other types of dark patterns and consent banners that are not rejection button related, or at least that exploit, for example, negative framing. If you reject, you will lose functionalities, which it's a very known text that exists so far. And so it could actually bring about exploitation of design, of location, of text, the wording, besides the reject button. And it is interesting to note, and I really want to bring research that is being peer-reviewed and important to this topic. In 2020, there was a user study that showed that users were prone still to accept consent, even with the decline button in a consent banner, when the accept button was shiny, with the text and with the color of the accept button highlighted, even with the decline button there. So I find that this cosmetic issue of one click fits all and solves all issue will not solve a thing at all. And I also want to bring the fact that there is a lot of research on dark patterns on consent banners already for a long time, which is actually mirrored in several regulatory cases of data protection authorities on deceptive design, on consent banners, and on guidelines on cookies that also reflect on dark patterns as well. And I still want to bring one last user study at stake. There is an important user study conducted by computer scientists and at EDRi and the CNIL that found out that exposing users to consent banners with dark patterns at least twice will nudge users to accept consent upon a new visit to another website, even if that website did not contain dark patterns at all. But because of this previous exposure, users tend to then accept, click on the accept button. So this is an interesting proposal at user interface level, but does not solve much, and requires, I'm sorry, but I really need to emphasize this, requires that the choices that users made at user interface level are also respected at the back end, are also respected behind the banner. So it is important that the user rejects, it's also registered and communicated downstream to all potential third parties. And in our work, we have found that decisions that were made at interface level are not recorded accordingly and also not communicated accordingly. And in our work on both rejection and both revocation, we have found that many CMPs, many websites and CMPs are not able to correctly register and to correctly communicate these decisions downstream. And so there is a potential right in theory, but needs to be exercised in practice, behind the scenes.
Yeah, and to further complicate matters, I observe that many of the e-privacy problems are dealt with in a very fragmented landscape. Like nudging, obviously, is also addressed in the Digital Services Act, but applies to only a few actors. Unfortunately, we have the Digital Fairness Act, which is going to extend some of these problems to B2B, so a much larger number of organizations will be subject to these new rules. Rosa, just maybe a very brief comment from you. Are businesses prepared for this emerging fragmented landscape of problems we see with cookies, with nudging, with consent, with opt-outs? Maybe a brief response to Cristiana on opt-outs.
So I think that business in general is coping with this now for a long time, that there is all here and there. But just to maybe go back to 2 points on the one click and the nudging and improvement of the banners. I find that, again, maybe I look at the picture a bit at the long perspective. When you remember how the cookie banners were 5 years ago or 6 and now is a huge change. Just to think about how they were provided now, many are already appear with one click. You have consent, reject. Same color. When you apply, you always say, don't prioritize a color over another. So there is a lot that has happened. Now, there is a lot of still compliance, but there was NOIB did a campaign. I think it resulted in a lot of changes in the configuration.
Maybe cosmetic changes. Cosmetic at the interface level, because our current legal and empirical works reflect on what happens behind the scenes and still finds a lot of non-compliance aspects. So I find them potential cosmetic user interface level changes that might not reflect in practice to what websites and CMPs are doing at the back end, behind the interface.
Maybe there is also a matter of enforcement. So, for example, it's possible that there might be a need to have a focus by the authorities on enforcing, because the rules. So to me, there are two things. One is the rules, whether the rules are there and they are good. There is guidance from the authorities about how to present the banners. The rules are there. question is it complied? Is a matter of compliance, not of new rules?
On that side, I agree, yes, it's an enforcement issue.
Before we move to the last block, a very short response from you, Itxaso.
I just wanted to say that we could spend hours and days speaking of cookies, but we already know that cookies are a thing of the past. So, and this is something that just shocked me the most about this proposal, right? Why this emphasis, this obsession with the so-called cookie fatigue that is actually has to do with deceptive design and lack of enforcement more so than, and why are we not looking into the many ways of pervasive tracking? Some of them mentioned by Cristiana, server-side tracking, fingerprinting, SD keys, and what we should do in order to actually address those from a regulatory perspective, but also from a design perspective. And this is something that is never going to stop to trick me, because we see Google has already left cookies behind, and cookies is something that is actually an inevitable choice for some companies that feel forced to use CMPs, right? Because most of the time, what's funny is that companies, or some companies, they do not know that they could not have a cookie banner as long as they wouldn't be using that data, but they're told that they need this cookie banner, and they're scared into all of these practices, which I think it's horrible because it entails a cost, and industry knows that much better than ourselves. But what are we going to do with this pervasive tracking that is, and the digital omnibus doesn't offer any solution. They keep insisting that it's going to be easier for citizens, and it's not just for citizens. Might I remind you that GDPR applies to all people in the European Union, not just citizens. That is going to make life simpler for companies, but companies refuse to have privacy signals because they know that if they had the choice, users will 99% choose to refuse the collection and processing of data. But I still don't see an answer about what we're going to do with all of these new techniques of tracking that keep being more and more sophisticated, and that keep causing more and more harm to society, to individuals and collectives as a whole, if I may.
Yeah, what we see is it begs the question of what fundamental right do we want to protect, and how does the new technology fit within that framing of the legal instruments you have to protect, which is a good bridge to like the last block on technical neutrality and future-proofing. And we've talked now about consent mechanisms and user control, but all of this assumes we're regulating technologies we understand. But the tracking landscape has moved far beyond cookies. And Cristiana, what's out there now that this proposal needs to contend with? New tracking technologies, we talked about server-side, a unified ID, cross-device tracking, maybe also bringing AI into the picture.
So just a brief mention that indeed there is a lot of tracking happening beyond the cookies. I'm very fortunate and honored to work with computer scientists that have been investigating other tracking technologies. One of them is developments on the server-side tracking, so tracking that happens on the server, not on the browser, and therefore is very hard to detect. And regulators should understand the consequences of this sort of tracking that is quite seamless. And we would be happy to discuss further the legal consequences for compliance for website owners as well. And then there is also developments on the side of tracking with first-party data. So with emails, user emails, with telephone numbers that users provide, for example, when subscribing to an account. And this data is used to create a unified ID called 2.0 that is used and that is shared all around by companies, and that is used to recognize the users across the web, across mobile environments, and across connected devices, TV-connected devices, and which is very nice because it renders quite a stable identification and provides quite granular profiles all across these modalities, and it is very nice for serving ads and for profiling. So where are regulators standing into these technologies that are being now deployed widely, considering, for example, server-side tracking, which actually is being selected as a way to circumvent technical issues, like loading time, and also block ads, but as a way to pervasively track users.
Itxaso, if you look at like the future-proofness of all this technology, do you see that the proposal is sufficiently protecting these new developments? And if not, what would be a good avenue to take into account?
Well,
Any advice?
We have already established that it isn't. It's when we've asked the Commission, they say that it should apply to other kinds of tracking. And there's a wonderful EDPB opinion reaffirming that Article 5.3 applies not just to cookies, but to all kinds of tracking, explaining some of them like fingerprinting. But the answer for me would be better enforcement, and better enforcement also requires more resources for DPAs to have all of the expertise to have. Sorry.
I think we are putting again the note on enforcement, but there is also a lack of compliance because there are no technical means that are standardized, for example, to assure that compliance happens on the back end. While there are no standardization, unified, streamlined methods to communicate consent decisions to third parties and to communicate and update them either through APIs, either to other mechanisms, and quite casuistic mechanisms, then how compliance happens. So this is also not only an enforcement aspect, but also about creating standardized technical mechanisms to help compliance to exist.
Yep.
And who establishes them should also be regulators.
And looking at the whole tracking stack.
Exactly.
Because, for example, when we speak about privacy signals, you mentioned that one of the problems is that browsers might get the privacy signal, but are they going to be bound? Which entities are going to be bound across the value chain of data processing? And I think that's a really important question. Yeah, I completely agree with that. But I really want to make the point, about enforcement. For me, compliance is part of enforcement because enforcement is also about guiding companies and telling them what to do. And the point that Olivier made about lack of resources, lack of resources is okay. It's, of course, a matter of material resources, but also of expertise. And what we know from the evolution of the e-privacy directive and the e-privacy regulation is that most of the focus was put on the good faith on companies applying and creating or engaging CMPs to have cookie banners instead of actually putting the focus on enforcement and how are we going to make sure that if self-regulation doesn't work, which I'm sorry, it doesn't work, this tracking is not going to happen, right? And we can create as much prohibit tracking as possible, which I'm a fan of, but we need to make sure that prohibit tracking works from the get-go, from across all of the value chain, and this is not happening. This is not happening at the very level of the browser. This is not happening at operating systems apps, and actually privacy signals should also apply to operating systems, whereas they don't, according to the proposal. And again, I don't think people who are making the laws are listening enough to people like Cristiana and the people you work with who actually know how tracking works, who actually know how tracking is evolving, and who actually know all of the actors who are actually participating in the new tracking techniques.
Before we hand off to the audience for questions, I'll give you one round to give a brief advice to the policymakers. If you had one message for policymakers working on this proposal, what would it be? And Rosa will have the first opportunity, then Itxaso, and then Cristiana. What's your one thing you would advise?
Yes, two. Number one is that ensuring that as this moves on, given that for me there is a certain balance here, to keep the balance and not to derail on any direction. So that, and second, courage. Having been there, I think it's a difficult one.
Itxaso.
do things properly, and the digital omnibus has not been done properly, so reject all of it. And if you have to do any of the things that you have suggested, you have to go to the digital fitness check and have a full impact assessment, follow the better regulation guidelines, have evidence, involve all of the stakeholders, industry, civil society, communities, and individuals who have been impacted, and good lawmaking will be a really good start, because I haven't seen any of that.
Cristiana.
I think the message I wanted to bring also departs from with whom I work with. And so and when reading this proposal, I see the need for the regulators to work or consult with technical people, so with computer scientists that constantly build tools, auditing tools, to check upon the effectiveness of the law, and actually that perform user studies to understand users' perceptions or misconceptions when they use or when they exercise their rights or when they cannot, and that can actually understand and compare what happens in the interface and at technical levels. So working with computer scientists.
Thank you so much. Let's open the floor, maybe for a few questions before we close out. There's a question in the back, and I see here in the front, Akim has a question.
Good evening, citizens. My name is Angelos Harlaftis, Epafos Advisors. We represent the open source codex community, which is trying to organize an open source in a perspective, a European perspective. I'm an old guide here. I would like to make a comment and a question. A comment for the lady at the video at the beginning, Lady Anne, who spoke about some things. Because why we don't have Google or Facebook or our own institutions, we have to think a little bit for the policies we have followed the last 60 years and maybe more, which the relation between USA and the Europeans was exactly like the relation they had with Moscow, the capitals of the communistic regimes before, because everything in the techno field was coming from them, from the Americans, and us, we were making the package in a European way. So the new relation has to be built in a respect to our culture, and also we have to build a relation with the Chinese and the Russians in the future. What do you think, your community, about our proposal from 2010 that privacy cannot exist in the internet field as a technological point without the creation of a parallel European internet, the CNET as I'm calling it, which the consumers or the citizens, they can change from the one to the other. It's a matter of protocols, and the endpoints will be in Europe, not in the USA like it's in internet. Thank you very much.
So this is basically about a redesign of how we exchange information. Maybe, Itxaso, have you done some thinking about that? Why do we not? I have heard some disruptive ideas about alternative internets. Is that happening in your community as well?
Yeah, I think, we have the best example we have with social media, with European options and alternatives like Mastodon, which is fully decentralized, and every community. I think there's advantages to that. From a data standpoint, I think the idea that the data stays in Europe and only moves, if I understood you right, only moves within Europe doesn't mean that data is not going to be abused. This is why I am fairly certain that there's many EU companies that respect the law and that want to respect the law, but there's also other EU companies that actually want to abuse the law and are using the excuse of American or Russian or Chinese companies having access to more data as to justify that. And I'm not sure. This is the eternal debate that we have with sovereignty. Sovereignty is amazing, but I don't want a European Google. Sorry, I don't want a European Meta. It's not because it has a European flag that is much better, and I'm going to feel safer because data can be used to harm me, even if it's just within the European Union. I don't know if I answered your question. I'm sorry.
center, and the other is on the east coast of the Americans, and over there they control all the data of the world. When the endpoints will be in Europe, then inside this circle we can have more. Abuse can happen always, but we can have more control, our protection agencies, to our data, which is the future, which is the richness, and also for the artificial intelligence, because it's another thing, the artificial intelligence, to be controlled by one, to circulate and take the data from one internet, and another thing from taking from 10 or 2 or 3. So, because these monsters, as I've spoken to the Eurocontrol conference last year, they can balance each other.
Let me bridge this, that the current developments of the blockage of internet in Iran has been quite impactful, and that should be taken as a warning, at least in resilience. Achim, you had a question as well.
He can change, he can beat on the internet. Or if he doesn't like internet, he comes to our internet. It's also a competition with the data.
It's a societal and architectural question. I thank you for your observations. Achim. Yeah, I'm not hearing you, Cloud and Leary yet.
So thank you. That's very nice of you, Rob. Thank you. I found the discussion with the panelists very helpful, in particular that Rosa pointed out that efforts to enforce from the civil society have actually changed the appearance of many sites, so that accept and reject buttons now on many sites have the same size and visibility, and so that there is at least the optical impression that things are better. Of course, as Cristiana pointed out, when it looks good at the surface, it doesn't mean that the user's will is respected inside, but that's much more difficult to verify. You can see whether a cookie is placed on your device or not, but you cannot see what happens with the data once it is in the hands of the server and the service provider. And then it's the question of enforcement by an authority which has the right to actually look into the server. So that's an issue. But on the other hand, firstly, this change which we observe has not been taken into account by the Commission. If you read the accompanying documents properly, the discussion is still as if we were 2010 or 2013, which is both 10 or 12 or 15 years ago. So things have changed since the status of the facts that, and even for the visible part of the website, if I take what, I mean, the first attempt to do an automatic signal was an IAB thing where you had to click no to 758 companies wanting individually for each one with one click to say that you don't accept legitimate interest processing from these companies. And now you can
still
actually...
happens.
Huh? Yes, I know. This is still there. I mean, they still, and many websites still use this model, and it's just outrageous. But there's another element which I think is not properly taken into account in the entire digital omnibus, and that is changes that have been observed very recently. One thing is that we had a journalistic research into the data broker industry, which revealed that there's a lot more happening to the data than what has been discussed in the legislative debates over the last 10 years. And much more recently, we have learned that DOJ and ICE in the US have not only collected all the personal data that was available in the federal administration for undisclosed use, but that they are also now, and other security services even in Europe are doing the same, buying data from data brokers, which also comes from online tracking, including very precise location data for security and surveillance purposes. And I think this is not a single mention in the entire digital omnibus and simplification regulation of these new developments. And I don't know whether I guess you have some research on this, and I would like to get your view on this. Thank you.
No, I just want to mention, thanks so much for this. I think I mentioned at the beginning why the e-privacy framework is so important, because it also acknowledges the way in which law enforcement authorities and other kinds of security service can access or cannot access our devices, or can access or can ask companies for the data. And this is why I was mentioning the Le Monde investigation, because we see more and more. The last year was the year in which we had more data breaches than ever. We know that there's data brokers that are selling our data to who knows what, exchanging data amongst themselves, and nobody is addressing that. The only moments in which we also had a very nice investigation by Netzpolitik and Le Monde, in which it was the moment in which maybe potentially people, decision makers in the European Union who had been using this GYM app, this sports app, maybe their most intimate data was also going to be used. But this is why I mentioned at the beginning, and if I didn't, I'm sorry, that we're looking at that with this obsession of cookies and addressing this cookie consent without looking at the bigger picture, which is, of course, deceptive design. And also, we don't have an ad tech regulation. This is the sector that is the least regulated, and one of the sectors that is the most dangerous to our rights and to our democracies, and we still don't have an ad tech regulation. I know there's a DMA component, I know there's a DSA component, but I was going to say a bad word, sorry, but we have a business model that I'm really sorry, at its core, it's completely illegal, and nobody is looking into how we stop. We are going to stop them, right? And we allow their practices, we indulge their practices. Maximum that we're going to do is going to ask a company to break up, which is really nice, but this is not the only problem with ad tech. And yes, again, TCF and EIAB, RTB were illegal from the very beginning. We have a court, we have DPA saying that. Why are we not enforcing that, for God's sake?
Just one simple note. We should learn from the US experience that obliges brokers to register and to disclose their data. And your point is also valid here, especially because brokers combine a lot of real-time bidding data also with these user data generated identifiers, so with offline data as well. So it is, how to say, free for all data. Maybe Rob could also add it, because you worked a lot on...
Are you referring to the DROP, the data deletion rights and opt-out platform of the Californian privacy regulator? I mean, I think the risk in the US is real. If you have like an abortion clinic, location data can throw a parameter around that. And if with data brokers you can find out whether someone has been in an abortion clinic, it may have legal consequences.
$160 was the price to act.
So the impact on individuals, like the violation of the rights of the individual, are real there. And that's different here in the EU, I guess. But still, the systems and the backends are the same deployed here in the EU market. And I think that definitely needs to be taken into account.
There are a couple of decisions, very few, on brokers, maybe 2 or 3 so far that I have studied, not so much. So they are not a regulatory target in the EU. But in the US, brokers are obliged to register and to disclose. Maybe we could have that, how to say, key... yeah, maybe you could have that lesson learned into the new proposal.
I have one more question here. And there's one in the back.
Thank you very much. Maybe a quick reaction on Teixeira's comments. I think saying that we don't have any legislation on AgTech is just false. I'm sorry, I'm going to strongly disagree here, but there are many rules and legislative framework applying to AgTech businesses. Is that enough? That's another question. But saying that no rules apply to them, it's not true. They have to apply to GDPR, they have to apply to many different laws. If that business is illegal or not, it is a legal business model. Is it aligning with data protection rules? That's another question. But like honestly, I can't let you say that this business model is not legitimate and that they have no regulation applied to them. I think what we have to keep in mind is today, a lot of the internet works with ads. Whether we like it or not, it's a different story. I think what we have to keep in mind is those business models need to respect data protection, need to respect data subject rights. And that's the focus, not whether a business model is legitimate or not. Thank you very much.
Yeah, I think I mentioned maybe a dedicated ad tech regulation that addresses the ad tech infrastructure, and there's nothing of the sort. And I mentioned that there's some legislation that addresses that, TSA, DMA, GDPR, and what I said it's illegal because there's a decision stating that it's illegal. Maybe I'm of that opinion, but there's an actual regulator that has said that RTB and TCF are illegal. I'm not inventing and I'm not making it. So thanks so much.
I saw one hand in the back, and then I'm going to hand off to Thomas and close out. Sir, go ahead.
Very much for the fantastic panel. I'm Giovanni Battista Gallus, DPO from several public organizations. I just wanted to know if you envisage any role in the data intermediaries as provided in the Data Governance Act in order to relieve the fatigue of online tracking, especially the burden on the user to refuse or to act in a positive or negative way in order to express its view on tracking.
Anyone?
So just a very short note. I remember that the Commission published, I think 2 years ago, a report on the use of CMPs in relation to the DGA. And so when I scrolled very quickly the report, I found that the Commission invoked certain CMPs that we, in our legal and empirical work with computer scientists, denoted that they are one of the most responsible actors for tracking users and through data collection practices, including dark patterns, by default and at scale. So I have some doubts about using certain CMPs and invoking them in a commission-based report, even for enabling data collection through intermediaries like the DGA uses. I would be very, very careful and very selective and grounding on current studies on CMPs.
Are you referring to the AWO report?
No.
Okay. Closing thoughts? If not, thank you very much for the engaging conversation. And thank you, audience, for the great questions.